Don't be rumble, float like a butterfly, and sting like a bee. Ah, rumble, young man, rumble. Down goes Frazier! Down goes Frazier!
It's time to get in the ring with the Cornerman, preparing dentists for the next round. We give you business insights, trends, and timely information. And we'll interview experts to help you make smart financial decisions. Now, here are your Cornermen, Rob Joyce and Mike Bark.
Hey, everybody. Welcome back to the Bull Moose Cornerman podcast. Today, we're joined by our tax partner, Megan Rutkowski. And a lot of the questions we've been asked lately have kind of gone around employees and coming back to work. And last week, we were lucky enough to have Corey Keel and Jill Shue on to talk about reopening procedures and things like that. Today, we're fortunate to be joined by Rob Driscoll from Reinhardt Law to talk about more of the legalities that are involved with things like the Americans with Disabilities Act, Family First Act, some of the things you need to be cognizant of as employees have different issues coming up and in the coming weeks and months as we go through the corona crisis. And then also some more evergreen things, some best practices that you can implement in terms of employee handbooks, hiring and firing of employees, independent contractor versus that. So we're going to introduce Rob, let him talk a little bit about himself and kind of go from there. Rob, thanks for coming.
Yeah, Mike, thanks for having me. Glad to be here. And everyone, thanks for joining us. A little bit about my background. I am a labor and employment attorney, a shareholder at Reinhardt Berner Van Duren. My offices are here in downtown Milwaukee. And I work a lot with employers, both litigation matters, but also a lot of counseling matters and helping small, mid-sized employers work through a lot of these issues that we're going to talk about today. As many of you know, running your own business, it's been a very busy and interesting time for labor and employment lawyers with so many things changing and transitioning. And we're going to get into that and just in the context of COVID-19 and everything else going on from it. The first thing that I wanted to go over for everyone was the Americans with Disabilities Act. The Americans with Disabilities Act applies to employers with 15 or more employees. And any of you who have dealt with it in the past know that it can be very difficult and complex area of law. And it's gotten even more difficult with COVID-19 because, there's a lot of questions coming out about whether employees need to be accommodated for disabilities that might relate to, in this case, masking requirements, as well as questions about testing for COVID and when it's okay and when it's not okay, what's not okay. And so I think it's really important if we start with this and then get into some of the more detailed discussion about the Families First Coronavirus Act as well as some other related issues that Mike mentioned. So many of you may know that the ADA applies to medical examinations. And there's only very narrow circumstances that you can require your employees to undergo a medical examination, a trip to the doctor, things of that nature. So for example, applicants, you can only require a medical exam after they've been given a conditional offer of employment. You can't do it before that offer of employment is made. And that applies in the COVID context as well. This would include things like screening for COVID symptoms, asking them to take a COVID test to determine whether they test positive and may have the virus or may have the disease as well. All of that has to come after you've made a conditional job offer. And for employees, it's very simple. The statement is very simple. The application is complex. You can only require a medical exam if it's consistent with business necessity. And one of those things would be if it's related to a direct threat the employee might cause other people. So what the EEOC has said is you can now scan for people's temperatures. That's a medical exam, but because we're in a pandemic, you can do so. Or you can require employees returning to work to take a COVID test to make sure they test negative. Because if they came to work positive, that would, of course, pose a direct threat to your other employees. The trick here is that this is constantly changing. If the number of cases continues to decline in many areas, it may no longer be a direct threat. Or it may no longer be justified to take everyone's temperatures. And so you have to constantly stay on top of what the relevant authorities are saying. With COVID tests, the challenge is you have to make sure that they are accurate and reliable to the best that you can. And when you get information back, whether it's on a scan or a COVID test, you have to keep that information confidential because the ADA imposes that on you as well. So kind of a second related issue that I'm seeing just a lot of now is masking requirements. I don't know how many of you out there require your employees to wear masks. Maybe some of you are required to because it's a healthcare setting. Other businesses like manufacturers are requiring people to as well. And the issue that comes up is someone that says, hey, I can't wear a mask because I have a mental health condition that, I just can't wear a mask all day. Or, I have a condition where it causes an extreme breakout on my nose or on my face and can't wear a mask all day. And it's very tempting as an employer to look at that situation and say, well, this is a pandemic, right? We take this seriously. No exceptions. We're not making any exceptions. I'm sorry you have this condition, but too bad. You can't do that because of the Americans with Disabilities Act. Any of you who have applied this in the past know that many conditions, maybe even most, are protected disabilities that have to be accommodated. And that even includes accommodations that may require exceptions to a masking policy. So for example, if you may have to consider someone to wear a face shield or to allow them to wear the mask off the nose. You might have to consider leave as a reasonable accommodation if they're unable to work as long as the mask requirement is in place. Or if it's possible, placing them somewhere in the office or in the plant that's away from others. All of these things are part of the reasonable accommodation process that you have to go through. The reason is it's simple. The courts and the EEOC find a lot of things as to be disabilities, and many of the problems that come up with masking will qualify as that. And so therefore you have an obligation to accommodate those, as difficult as it may be. And you have to talk to the employee about it, try and find solutions rather than just giving a blanket no.
Rob, do they have to have any type of excuse or any type of documentation for what they might be claiming to not wear a mask, or is it simply their word?
Yeah, that's a great question, Mike. To make the request for an accommodation itself, they don't have to use any magic words. They don't have to say, I need an accommodation because of a disability. And they don't necessarily have to ask anyone specifically. For example, if they see a frontline supervisor and say, hey, I really can't wear this mask. It's really inflaming my skin condition. That supervisor has to know and be trained to understand that as an accommodation request. Once you've done that, then usually in most cases, the employer is able to go to that employee and ask for information showing that the condition is a disability, number one, and that there's a disability related need for the accommodation that they are requesting, and maybe other information about other potential accommodations. The difficulty is usually you're going to get something back on this particular question fairly opaque and maybe not very detailed, and it may be an honest dispute over whether the condition is a disability or not. But in most cases, to avoid any sort of dispute or litigation, you're going to assume that it is a disability once you get that information and then try to accommodate with the employee as best you can. I'm not saying that you need to say in every case, yep, you don't have to wear a mask at all, but there may be some other steps that you might be able to take. For example, wearing a neck gaiter instead of a mask. I know that there's products out there that actually go over your face, and so the mask doesn't touch your nose or touch your mouth, which may help people in certain circumstances as well.
Would that cover even people who are working in most of our clients out there are in a medical setting? Would that act cover them within the context of a medical setting?
It's certainly going to cover them, assuming they're 15 employees. And then the Wisconsin Act is actually just about every employer in Wisconsin, so it's very similar principles there. But I think where the difference is going to come in is what a reasonable accommodation is in that setting. So, you could imagine for a dentist's office, right, where someone's working very closely in the face of someone else, that it's not a reasonable accommodation to allow someone not to wear a mask or only a face shield or something like that. But there may be other accommodations available that are just as effective as the mask policy that you would have to consider. If not, then I think the position you take is that, look, because of the nature of our work, we can't make an exception to this policy. We've worked with you, and unfortunately, we can provide you leave if you're unable to work because of this policy, as long as this policy stays in effect.
And that leave would be covered under the FMLA, or just the employer being generous with an employee and saying, hey, you don't have to work, or we'll hold your job open.
Yeah, it's really going to be required actually by the ADA. The ADA does require some extent of leave. How much, you'd have to talk with your employment counsel to kind of figure that out. It's not a bright line rule. It potentially could be covered by the FMLA as well, if the condition's a serious health condition. And you'd have to go through that analysis, assuming you're a big enough employer to be covered by the FMLA, and the employee is also at a work location 50 employees or more, and has been employed for 1,250 hours. If they meet those requirements, then it could potentially be FMLA on top of that. And the two will kind of run side by side with one another. So, I think everyone is kind of familiar with all the CDC guidelines. I'm sure most people are probably sick about hearing of them. I just note that some of them change from time to time, and there's still good guidance for how you run your workplace and how you develop your policies related to COVID. For example, the CDC has kind of cut down on the quarantine time to 10 days for certain individuals, especially those without symptoms ever appearing. Wisconsin still has a longer time period of 14 days. They're not necessarily required in either for employers in any setting, but they're really good to know and to follow because they're constantly being updated. I've just recently read that CDC maybe have changed their travel recommendations as well, and so you should always be kind of aware of what those are when you're making your policies on employees who travel outside the state or internationally or on public transport too.
With somebody who comes into work and says they may have had an exposure, it's an issue we're running into a lot with offices, that they may have been somewhere and somebody that they kind of tangentially knows it was a positive test, and now they want 2 weeks off. That's not something they're going to qualify for necessarily, is it?
Not necessarily, and that gets right into the next slide. You're squarely under the Families First Coronavirus Act at that point, kind of referred to as FFICRA is kind of the shorthand that we used for it. And merely kind of maybe been exposed to someone with the virus is just not enough on its own to qualify for that leave. You need to be actually experiencing symptoms and then also seeking a medical diagnosis to qualify, or to have a healthcare provider telling that employee to self-quarantine. So Mike, I think in your situation, you were saying that they just maybe had a run-in with someone and didn't necessarily have symptoms afterwards. Is that kind of the thought?
Yeah, I think the most common one that we're encountering, or the biggest question we're getting from a client, is somebody happened to be somewhere where somebody happened to test positive. So now the weather's going to be nice for the 2 weeks. So if they can please quarantine, that would be good by them. But they clearly need to have some type of symptom or some type of doctor's excuse to be able to collect on it, correct?
Yeah, in that case, yeah. I mean, the first condition for the paid sick leave portion of FFICRA is subject to a federal, state, or local quarantine or isolation order, which wouldn't apply in your situation that you outlined. The second, though, is that they've been advised by a healthcare provider to self-quarantine. So they would actually need to find a healthcare provider who will then tell them to self-quarantine. Once they get that information and then pass it along, I wouldn't advise turning it down. It is reimbursable through the taxation, which you well know. And then the third condition or third possibility is the employee is experiencing symptoms. So again, they're not experiencing any symptoms. The mere fact that they ran across someone that they later found out had COVID is simply not enough. They had to then experience symptoms and be seeking a medical diagnosis in order to get it. Presumably, once they get that medical diagnosis, their doctor is going to tell them to self-quarantine as well. And so the two kind of work in tandem with one another.
That kind of brings us into the family leave, which is a little broader, not necessarily broader, but allows for more compensation. And it's certainly something as school starts ramping up again that a lot of parents are going to have to deal with, depending on the school situation. But in your mind, it's basically going to be for somebody who has to care for a child that, because their school is closed, now they can get up to 10 weeks of additional pay, correct?
Yeah, that's right. It's actually up to 12 weeks. The first 2 weeks would be unpaid, but someone could choose to kind of combine the paid sick leave portion with the family medical leave portion to get 12 total unpaid weeks. Or in some circumstances, they could actually get up to 14 weeks, 2 being unpaid, but the other 12 being paid because of the combination of the two. As I think you know, one of the conditions for getting paid sick leave is also to take care of a child whose school has been closed. And so, I think you raise a great point, Mike, is about school coming back in. Many of you have children. Maybe your school is still closed. Others, say the high schools in Milwaukee. I know Marquette High, for example, is on a hybrid program. And I think all schools in Milwaukee, maybe at best, are on a hybrid program because of Milwaukee's own health commissioner's rules. And so what do you do there, right? What do you do when your child is home 2 days a week, but then in school 3 days a week, and then, home 3 days a week, and then in school 2 days a week? How do you deal with that? And the guidance from the Department of Labor on that is pretty clear, actually, that your child's school is considered closed, or the employee's child's school is considered closed on the days when that child is home, even if they're virtually learning and the school is otherwise open for kids that are there. So you may have a situation as an employer where an employee is asking for family medical leave, paid family medical leave for like 2 days a week here and then 3 days a week the next week. And that could be perfectly legitimate, assuming that, they provide the documentation required and, there's no other caregiver that's able to take care of their child. When it gets a little bit older, when kids get a little bit older into the 15-year-old, 16-year-old range, your employees do have to provide a statement showing why that child, who's, again, older and presumably responsible enough to care for themselves, still needs a parent at home. But for everyone else, you could have a situation with employees basically taking intermittent leave for that hybrid situation.
So a parent who chooses, because a lot of schools do have the option of you can attend in person or you could go virtually. If the parent chooses virtually and that's the education path that they choose, there's nothing to really prevent them from qualifying for an FMLA, is there?
Actually, there is in that situation, because the key word that you're using is the choice, because it's voluntary, because the school is actually not closed for them. They've chosen to be home all of the time. And I presume if that applies to a hybrid, where maybe a parent chooses a hybrid plan when they could choose everyone to be in school, it might apply there equally as well. And it's hard. It can be very hard to get this information right. But there is an argument, and I think the DOL would support this, that a parent who chooses to keep their kid home all the time when the child could otherwise be in school, in person, in classes learning, is not qualified for family medical leave under the Act, or at least paid family medical leave.
So if a parent represents their child can't be in person, they actually can be, how does that affect the payroll tax credit on the back end? Who's responsible for that type of record keeping?
So you mean if they said they've chosen not to send their child to school even though they otherwise could, and the school would be open for them?
Right, correct.
Yeah, well, I think in that case, I'm sorry, go ahead.
It's the responsibility of the employer to verify that information.
Yeah, I think they have to ask and get a statement from the employee about why their child is home. And if they can't get it, or the statement comes back as, well, we've just chosen to keep the child home rather than sending him or her 2 days a week or even 5 days a week, then they wouldn't be qualified for the leave. And the employer certainly could make arrangements otherwise and pay something or allow them to take vacation or whatnot, but then it's not going to be reimbursable through the payroll tax, and they're not entitled to that leave. I think you got to very carefully analyze the situation, though, and make sure, because there's such fine lines here, distinctions, and make sure it's truly the case that this is a voluntary choice. And even then, probably a review of the regulations before you make a decision is a good idea.
A lot of clients have asked about exemptions, and I think it was a big deal, especially as the sick pay law was starting to come down, was kind of a thought, especially by a lot of consultants, of you need to terminate your employees now so you do not become eligible for this sick pay thing. And in our mind, it wasn't a big deal to be eligible for the sick pay because it is reimbursed through the government. Have you seen a number of your clients apply for exemptions? Is there a clear-cut process to who gets approved? maybe for an exemption and who doesn't? What's your thoughts on just getting exemptions in general?
I think you're right that when things first started, there's a little bit of a panic that set in, especially among smaller employers, and justifiably so. This is a big burden, and they probably weren't sure if they'd be carrying on their business at all, let alone having to worry about a new paid leave entitlement. But I think as the exemption, the contours of it became clear, we kind of quickly realized it wasn't going to help most people. Most companies weren't going to be benefited by it. Now, there isn't really a process in place to get approval for it. You just have to meet a couple of steps, and if you're ever challenged, hope that then those steps kind of insulate you from liability of any kind. Basically is showing that the small business's financial viability would be jeopardized by giving this particular employee paid leave, or that there would be a substantial risk because that person is just so key to the business that you couldn't do without them. And then you have to have an officer sign off that all these things are the case. Problem is, and as accountants, this, the people that are getting leave, you're going to be able to get reimbursement for it. It might be delayed. So it's hard to say that merely paying the leave is going to cause the business to go into financial distress. And so it became very narrow for people. And I think employees realize that, it's a nice benefit to have, but it doesn't pay their full wages, or maybe in many cases even close to it. And so they weren't going to take it unless it was absolutely necessary for them to do so. And so employers didn't feel the pressure to actually claim the exemption.
Now, there's been a big case out of New York that you could probably get into a little bit as it relates to all this. What's going on with that, and how is that going to impact business?
Yeah, that's the big kind of the 800-pound gorilla in the room right now. Maybe just a quick background on the legal side of things for folks that aren't familiar or too familiar with the court system. And if you're not a lawyer, it's great if you're not familiar with our court system. But the country is divided into districts for federal courts that apply the law of the national government. For example, here in Milwaukee, we're in the Eastern District of Wisconsin. There's a Western District of Wisconsin as well. And in this case, this is a decision out of the Southern District of New York, which includes New York City. So it's a very prominent and major court. And that's important because normally a court of that level only has authority over the people or the agencies within it. So the Southern District of New York, a decision there doesn't bind a judge here in Wisconsin. So they're two different courts and they're equal in their authority. But this decision may be different, and many decisions against the government may be different. So keep that in mind. I think I'll talk about that a little bit more. But this court in the Southern District of New York ruled that many of the Department of Labor's regulations implementing FFICRA, a lot of the stuff we've talked about already, are unenforceable for various legal reasons that aren't really important here. But the state of New York had sued trying to invalidate them, and the court agreed with the state of New York. So the first one, and this is the one that's maybe most difficult to get my head around, maybe all of yours as well, is the work availability requirement. So the regulations had said, look, if you're an employer and you don't have any work for an employee, maybe you furloughed them, they've been laid off, whatever the case, maybe you're shut down completely or were shut down completely by an order from your state, right? What the Department of Labor said is, you don't have to provide paid leave in those situations. Why would you? The employees aren't working anyway. Paid leave is designed to give people who are otherwise working a break to deal with these issues. And in maybe a shocking, very surprising, certainly decision, the court in New York got rid of that requirement. And the upshot of that is you could have an employee that's on furlough status because you don't have enough work for him or her. Maybe you're at half capacity, whatever the case may be. And they still could apply for Families First Coronavirus Act paid leave if they otherwise meet those requirements that we talked about. There is no requirement, in other words, that they actually be working or that you as an employer have work for them. And you can see how the confusion that something like this would cause. And, Mike and Megan, you deal, I think, deal with unemployment as well. I think there's an open question how that affects, what if that furloughed employee was on unemployment at the time and how those two interact with one another? Because normally you wouldn't have been entitled to unemployment during that if you were on Families First Coronavirus Act leave as well. So that's a major change from this district court case. Another one is and it applies to maybe many of you on this call right now, is the definition of healthcare provider. So what FFICRA had said was that healthcare providers, employees of healthcare providers, don't qualify for FFICRA leave at all. The idea being you don't want many of your frontline healthcare workers taking leave and leaving the hospitals understaffed when you're in the middle of a pandemic. And the Department of Labor had provided an incredibly broad definition for who counts as a healthcare provider. Even folks that just worked for maybe healthcare companies but didn't actually have any role in providing healthcare treatment and things to patients. And so the court in New York actually struck down that definition and said that's way too broad and left it kind of open as to who qualifies for a healthcare worker. And so it's really difficult for employers in that setting to determine now whether a particular employee is exempt from the FFICRA leave or whether they now can keep it or take it given this decision from the court in New York.
With everybody returning now and kind of coming back to work, are there any OSHA things that people need to be concerned about or safety things? I know various dental societies have come out, and including the World Health Organization, and has essentially said only routine dental care should be done right now, which has led hygiene groups to go and say, well, my job's too dangerous to do. Do they have any rights in that circumstance to not work? Can they be compelled to work? How is that all coming together?
Yeah, that's a great question. And before I forget, let me just wrap up one thing about the case in New York. As I mentioned before, it's in New York. There's an open question about whether this applies to all employers or not. And so that's something, whether you're going to comply with it as an employer, talk to your employment counsel about, because it's not clear whether someone here in Wisconsin now has to follow what this New York court has said, or whether they should still be following the Department of Labor's guidelines. Yeah, so with safety, it's a real complex issue because there's, again, so many different laws. OSHA certainly being one of them. Now, OSHA has said that cloth mask wearing is not a form of personal protective equipment. Surgical masks and respirators, of course, would be. So cloth masks aren't as important in OSHA's mind as maybe in other settings, maybe what the CDC recommends and whatnot. And it's also possible from OSHA's perspective that a cloth mask actually, a requirement, given the circumstance, could be unlawful in OSHA if it increases the employee's, the threat to an employee. Perhaps they're working around extreme heat and it could catch on fire or whatever the case may be. So when you're implementing a mask policy, you have to be really careful that, the employees that are in that setting can safely wear a cloth or, otherwise mask. So you always have to take that into account. I think, Mike, where you're going though, really in many cases falls under the National Labor Relations Act. And many of the participants here may be thinking, oh, this doesn't apply to me. I'm a non-union company. I don't have any union employees. Everyone here is at will. I hire them when I want, I fire them when I want. It doesn't apply to me. And that's actually a really common misperception that many people have. The National Labor Relations Act actually applies to every employer, more or less in the country, whether you have a union or not. And there's certain rights in there that every employee has, regardless of whether they're in a union. And one of those is to protest unsafe working conditions. We've seen, for example, in Amazon facilities, employees walking out because they thought the conditions in those facilities were unsafe. And generally speaking, because they're doing that as a group activity, and they have a right to do so. It's kind of one of the hardest things to explain in employment law. I frankly don't get it myself, but there's no requirement that those employees have a objectively reasonable belief that a safety condition actually exists. They may think it's unsafe themselves. They could be completely wrong, but as long as they think it themselves and they're doing it as a group, they have certain rights to be able to walk out and protest what they perceive to be safety. And that's why, we always recommend the hand washing, maybe a masking policy, social distancing where you can, having policies in place to keep sick people out of the workplace. All those things make it easier to win any case where maybe someone walks out because of safety, or OSHA comes in your door and wants to make sure everything's being safe. It's really designed to preempt that, as well as of course provide for the safety of employees, but to be able to show that you're being proactive in those settings.
And so this applies only if it's the entire group walking out, or could it be a subset of the employees? Again, just to use a dental office as an example, if the hygienists decide, look, we're in too close a proximity with all of this, we're in harm's way, the front office person may say, well, I'm behind a plexiglass thing and I'm always 6 feet away from somebody. I don't have some of the same concerns. Could just the hygienist walk off, or does it have to be the whole group?
No, it can be a subset. The key is group action of some kind, or the action of an individual designed to vindicate group rights. The language in the NLRA is concerted activities for mutual aid and protection. So concerted, acting in concert with one another is the key to that. And that can include someone who on their own stands up and really just tries to convince others to join with him or her and protesting these unsafe work conditions. That could be potentially protected activity. And so you could have just a small group of people that walk out, or that you're even talking about unsafe conditions on Facebook, even with the goal of remedying that. And that is very likely to be protected. And so as an employer, you'd have to be very careful about how you handle a situation like that in terms of termination. The line that the courts, the NLRB and the National Labor Relations Board draws is, concerted activity is often protected. There are some exceptions, things that can bring it outside of the protection, but individual griping is not protected. So if it's someone who's just really concerned about themselves and is just complaining for their own sake and things of that nature, it's probably not protected, but you need to, again, speak with employment counsel to make sure that you're, kind of in tune with what that actual, it's very fact specific, in other words, and what that actual, where that falls on the side of the line.
Is there any leeway for, if you're an employer, certain jobs I would believe have some level of assumed risk. For example, if you're playing in the NFL or something like that, there's some assumed risk there. Would that be the same for, again, somebody who's a dental hygienist who may be in closer proximity to something like this, and that's necessary in order for them to complete their job?
Yeah, perhaps. Certainly, working, me sitting here in my office is a lot different safety profile than someone working in a steel mill. They're just inherent in it. And so it might depend on the nature of what you're doing. At the same time, if the employee has, a belief that something that they're doing is unsafe because, a certain precaution could be taken that alleviated it, or maybe there's an OSHA standard that's not being followed in their opinion, that's going to give them a lot of leeway to work on behalf of others to kind of vindicate what they believe to be unsafe working conditions.
And then an employer at the end of the day, does this issue get litigated? Is it arbitrated? What's the resolution to an issue like this? If a group of employees walks off, and we're saying the employer can't retaliate for it, how does this get resolved?
Yeah, a lot of times it gets resolved through the employer taking actions to address those concerns. If it goes to litigation, it's resolved usually in one of two ways. They can file a charge, the employee can file a charge with the National Labor Relations Board saying that it is unfair labor practice to keep these abnormally unsafe conditions, or they can go to OSHA and file a very similar charge, in which case OSHA will investigate rather than the National Labor Relations Board. There are two different paths. The agencies will investigate independently, and if they find a violation, they usually try to work out a solution, or even before they found a violation, they try to work out a compromise or mediate some sort of resolution. And if they can't do that, then they make a determination that, yes, there's been a violation and OSHA or the board is going to litigate the case, or no, there hasn't been a violation and we're going to dismiss the charges against the company. Those are very expensive cases because they go to federal court and they take a while, and there's a lot of lawyers and a lot of attorneys' fees involved. So most of them don't get that far. They usually get resolved one way or another through kind of working it out between the parties with the agency in between.
So in terms of accommodating employees and things like that, if somebody just simply comes in and says it's unsafe, they do have some measure of recourse to have that, or basically refuse a right to work, or right to refuse work, or be the better terminology.
Yeah, there is some recourse. It's kind of narrow, but talk to employment counsel before you kind of have a reaction just to fire someone or mark them up. because you want to talk about what that strategy might look like. A lot of times, and I've seen these in kind of the popular press, they tend to dissolve of their own. They might be kind of more of an attention gathering device that then kind of peters out after a few days. Or if there is legitimacy to them and there was actually an unsafe working condition, the employer is going to want to move to correct that condition as fast as possible to reduce or eliminate any chance of liability for it. And that usually brings people back to work because folks don't want to be out of work too long and not working and not being paid.
And is there, anything specific that would constitute dangerous work environment other than just having it be litigated through the process or go through the process with the labor board?
What do you mean? I'm not sure I understand the question.
Just in terms of an employee's claim of dangerous work. I was saying it's a danger other than going through the process. There's no real hard and fast rules as to you're in the wrong or you're not in the wrong when it comes to providing a safe work environment, correct?
Well, there are some. OSHA has some hard and fast rules, but a lot of it, you're right, would fall under what's known as the general duty clause. I think I might have it up here, that it's just kind of a general duty to protect people's safety, and what that means in any given circumstances can differ. And so that's what I was saying about even like the cloth masks, right? In some cases, maybe in most, you're following CDC guidelines to protect safety by wearing them. But you could see OSHA saying in some cases that that's harmful and you're violating your general duty to keep people safe by requiring them to wear a mask. So a lot of it depends on the particular factual setting of the workplace.
So is OSHA kind of the gospel for safe workplace, and then with COVID coming this year, then maybe the CDC people look to? What sources should the employers be keeping up with?
Yeah, OSHA is a great resource to start with, since they're primarily responsible for it. Your state level OSHA agencies are very similar in that regard. I think if you are following CDC guidelines for workplaces, depending on what your workplace is, whether it's a dental office or a restaurant or a factory or an office, whatever, following those CDC guidelines is going to go a long way to fulfilling any OSHA requirements that you may have. CDC itself doesn't have jurisdiction over an employer, right? They're acting as a kind of a guidance agency that's just kind of giving people best practices. But by adopting those best practices, employers are going to go a long way to protecting themselves against any liability from OSHA, who investigates, or under the National Labor Relations Board if they get involved as well. And they apply very similar standards of safety as OSHA would, and maybe in some cases kind of defers to what OSHA would do in a given situation.
Shifting gears a little bit, I think more typical workplace environments and whatnot, we've always sort of encouraged our clients to go out and look at getting an employee handbook and those kind of things, even though it's not the most fun thing to work yourself through. What kind of advantages does the employee handbook offer somebody? And if somebody does have one in place, do they have to adjust that to kind of deal with the new environment that we're in right now and deal with things like COVID?
Yeah, that's a great topic, Mike. In almost all cases, I recommend having a handbook, but it's always better to have no handbook rather than one that doesn't comply with the law, right? Because if you have one that's not very good, you're going to be in a lot of trouble. So if you're going to have one, go through the effort to get a good one. You can go through employment counsel. Many HR consulting firms will provide handbooks. It's usually good to also have counsel review those. You can develop them on your own and have counsel review, just because there's so many legal principles that get packed into those, and you want to make sure you're doing the right thing. And I think if you have one that, kind of the principles are sound for general employment issues, that's going to cover a lot of the stuff that we're talking about here today, right? Even in the COVID setting. So we talked about reasonable accommodations. Presumably you have a handbook that says we will accommodate disabilities. Here's the process to follow. Fill out this form, and we will get back to you within 3 days, or whatever the case may be. And it also hopefully says something like, but we will still consider it even if you don't fill out the form. If you just call us, call HR or this person who functions as HR and talk to us. And so you're kind of giving employees steps along the way. And it also gives then your internal team, your internal staff, something to look for, right? When something happens, something to look for, to be able to follow, and having those processes in place so that you have a very consistent means of enforcing these protections. One area that's constantly in flux, we won't go into any detail about it, but is the National Labor Relations Act, because for a while under the board that was primarily appointed by President Obama had very restrictive rules on what you could require. So, for example, it would violate the NLRA to tell employees to be civil with one another. There is decisions along those lines. That's changing now. And those things change oftentimes with presidential administrations. So you always have to keep up to date with those changes. And certainly the Families First Coronavirus Act is one of those changes now, but you can deal with that kind of through a side policy or an addendum to your handbook, just so employers have that, you have that guidance and you don't have to keep reinventing the wheel each time.
Can you talk a little bit about what at-will employment means? I guess that's part of the handbook, but I know Wisconsin's an at-will state. And what kind of situations are you able to just let somebody go without, like, unrelated to the topics we just talked about?
Yeah. So, most states in the country are considered at-will, which is, defined that either party, the employee or the employer, can, terminate the relationship with the other at any time for any reason. It's a little bit deceiving, though, because every state qualifies that somewhat, right? And so here in Wisconsin, or even the federal government, but here in Wisconsin, we have the Wisconsin Fair Employment Act, which outlines many protected categories of employees. And so everyone here knows that you cannot fire someone because of their race. That's a restriction on at-will employment, because it's taking away a reason that you can let someone go, or because of someone's sex, or because of disability, or the innumerable other protected characteristics there. All of that is a check on full at-will employment. What it means kind of then in practice is, as long as it's not for one of those protected reasons, you can let someone go for whatever you want. The big areas where that doesn't apply anymore is in the union setting. If you have a union, you have a collective bargaining agreement, and that says you can only let people go for just cause. Or you might have an employment contract, an employment agreement with someone that says they will only be let go for cause, and then lists what those reasons are that they can be let go. But again, very specific situations. And Megan, you mentioned, I think you said the handbook too, Mike, in the handbook. That's really important. Your handbook should say that everyone's an at-will employee, because unless there's something to the contrary, and should say that relationship can't be altered unless a particular person at the company says that it's been altered, because you don't want your handbook to be turned into a cause termination document requiring certain reasons before you let people go.
And in terms of, I think one misconception a lot of people have is, if I am going to fire somebody, I need to have all this document that I need to have, basically a list or a file of somebody that proves they should be fired. That's really not the case, though, is it?
It's not required. And in many cases, it's not even necessary. For example, you can think of some really egregious situations, fighting on the shop floor, a physical altercation. You probably don't need too much to fire someone for that. I think when you're dealing with performance issues, it's always good to have a paper trail, documentation, not just because it's fair to employees, right? I think all of us would want to know that our performance is slipping before we're let go of that, give us a chance to do better, or a particular conduct issue. Maybe someone, slipped up and just got really angry for something and, cursed out someone else and, get a chance to say, yeah, I shouldn't have done that. I'm going to do better. So from a fairness standpoint, it's good. But in those situations, it's also good from a legal standpoint. You don't need it. But if there is a dispute and someone then later says, well, you didn't let me go because my performance was awful. It was because, I am, 55 years old and you just wanted to hire someone younger. Well, it'd be really nice to be able to show, no, that had nothing to do with it. We've been telling you for 3, 4, 5 months that your performance was bad. We gave you opportunities to get better. You didn't, and we let you go because of that. And that's true in other settings as well, regardless of the reason for it. So it's one of those things where it's not required necessarily, but it's usually a good idea to have it. And even in those egregious situations that I mentioned, a lot of times it's good to paper the file and just have someone describe what happened, put it in the employee's file in case you need it later, right? Because memories fade. And that's what documentation is good for, is to make sure that, people remember what happened.
And is it okay, if you have your employee handbook that is kind of the overriding everything within an office, to cut a separate, like an associate contract with somebody, or for lack of a better term, separate deals with different employees, as long as it's within the context of that employee handbook? Or can it be something totally different based on their role in the company?
Yeah, it's both. It's not unusual to have employee handbooks apply to certain subgroups of people. In a union setting, you might have a handbook for the non-union employees, say, working in the office, but the union employees working on the shop floor are covered by the collective bargaining agreement. And if you have certain higher level employees, usually that have an employment contract, a lot of times that will have special provisions, right? Maybe give us more vacation time, or provides for a cell phone reimbursement or a company car. That's all that's acceptable. Many times those employment agreements, though, also say something to the effect of, you're bound by the other provisions of company policy, which would include the handbook and may include things like conduct and performance and things of that nature. Because in other words, just because you have, say, a contract with someone, an associate's agreement, that doesn't mean it's a for-cause relationship. It could still very well be an at-will relationship, but you're just providing different terms, maybe a little better terms, giving someone assurances as to their pay, how much they're being paid, a bonus that maybe many other people aren't able to get, or maybe you have a commission plan that applies only to salespeople rather than to the office staff, things of that nature that you can apply to individual groups.
I think one other big issue people have with employment law, specifically in the dental niche that we sort of serve, is what constitutes an independent contractor and what constitutes an employee. And there seems to be a lot of confusion with regards to that, even though it seems like it's pretty bright line laws to what constitutes each role. Do you go into that?
Yeah, sure. That's an evergreen issue. You're right. The big news on that is really to California and California employers, where they've passed a state law that's incredibly restrictive as to who is an independent contractor. And kind of the latest news in the employment world the past couple of weeks is a California court applied this bill, it's known as AB 5, Assembly Bill 5, to Uber and to Lyft, and basically said, no, all your drivers are employees rather than independent contractors. And in response to that decision, Lyft and maybe even Uber too said, we're suspending all service in California. That decision, I think that decision was maybe put on hold, so I don't know if Lyft has followed through yet. But it's that consequential that if the decision is upheld or if the law isn't changed, you could have no more ride sharing in the state of California. Other places, though, there's various tests for independent contractors. As accountants, I'm sure you're familiar with the IRS test, right? That's the big one, withholding of taxes. Wisconsin, though, has other ones. As you probably know, too, unemployment has a test for independent contractors. Workers' comp has a test. Then there's a common law test that the courts apply. So all these varying level ones. The key issue in all of them is control. Who's controlling what the person is doing? If the employee if the person has a lot of control over how they do the work, when they do the work, et cetera, they're more likely to be an independent contractor. If they're being directed to do the work and how they do work by someone, they're probably an employee. And I think one of the areas that employers have to be very wary of is not to say, well, we're just going to change. We have an employee. We're just going to change them to an independent contractor. The job's not going to change. They're going to work at the same desk. We're just going to make them an independent contractor. We'll have them sign an agreement. It's not a good idea. That's a red flag for any agency that would look at it. They would say, well, what really changed in the relationship that made them now to be an independent contractor? And going through that bright line test, like you said, and trying to weigh which factors weigh on each side of that line.
And I think the biggest one we have is, an associate dentist comes in, and in our mind, it's always been a very clear cut. If it's an associate general dentist who's working a set schedule, that's an employee, and there's really no two ways around it. However, the periodontist who might come in one time a month and see some cases and might be bringing even their own assistant in, that's probably a contractor in those particular cases, correct?
Yeah, that's much more likely to be the case. And one of the hallmarks of control is, who stands to profit and loss. If someone's paid the same, getting a wage, they're much more likely to be an employee. If someone's just charging a blanket monthly rate, and is responsible for business taxes, and they have their own employees themselves, and they work for other people, and they could lose money on their job, the jobs they contract for, they're much more likely to be considered an independent contractor.
We'll get you out of here on a couple final things. One, we always give people the opportunity to plug something. Anything going on at Reinhardt that you want to plug? Any legal stuff?
Yeah, so the legal stuff is always fun, at least for me, maybe not so much for everyone listening. I think the Families First Coronavirus Act, in some ways it's calmed down since April. People are in the rhythm of it a little bit more, but there's still a lot of questions about it. If you have more questions about how it applies, how it's calculated, all that, go to reinhardtlaw.com and look up in our Coronavirus Resource Center. There was a webinar that we did a few weeks ago that went into a lot of detail about the FFICRA. And it might answer a lot of your questions for it. Otherwise, I think stay tuned. Try and get on law firm labor and employment updates, because as I mentioned, things are always changing. And so grab the bull by the horns a little bit here and figure out when things might change that affect your business and be proactive about them. Talk to your counsel, talk to your accountants, and so that you're not surprised by something that may be put in place in a week or two, and you're not ready for it.
And Rob has a similar flaw to me in that he's a Chicago Bears fan. On this trivia question, since 1992, the Packers have had 2 starting quarterbacks primarily. The Bears have had 32. How many can you name?
Caleb Haney, Jay Cutler, Henry Burris, Cade McNown. I guess Nick Foles not quite yet. Mitch Trubisky, Jim Miller, Eric Kramer. Oh boy, there's a lot that I'm missing.
That's it. You're forgetting P.T. Willis, Harbaugh, Steve Walsh, Moses Moreno, Shane Matthews, and who could forget Kyle Orton and Jonathan Quinn?
Right, Rex Grossman, yeah.
Rex Grossman.
I will say a number of years ago, I had my Packers friends in the office here left a gift for me into the office that I keep around, and it's Brian Urlacher. And so he's always in my office watching over me and probably protecting me from the wrath of all the Packers fans here.
The office linebacker. Perfect.
That's right.
Thanks for coming here. Again, he's Rob Driscoll. You can reach him at Reinhardt Law if you have any specific questions. They do a great job with all of this stuff. And whether it's employee handbooks or consulting on some of these issues, they're a firm that we use for certain matters, and we can't recommend them enough. So thanks for being on, and we'll talk soon.
Thank you both, and thanks to everyone over at Bull Moose. Have a good day.
Thank you for listening to The Cornerman. Be sure to leave us a review and subscribe to us wherever podcasts are found. For more insights and information, visit us at bullmoosefinancial.com.